Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, April 8th, 2025 at 9:01 in the morning. We're beginning our week and our day today. Looking at F69 and activating the appropriate design code. At your institution, Senator Harrison, good morning. Thank you for joining us. You could give us an overview of S69.
Thank you, Chair Marcotte and the rest of the committee. It's great to be here. I am super excited about S69. I think it gives really very necessary protections to children in Vermont. And it did pass the Senate 25-5. I'll go through some of the information that I provided to the Senate at that time. And it's an internet child protection bill aimed at protecting the safety and privacy of children in Vermont. It requires businesses that offer certain online services that are directed to children to design their services in a way that is not unreasonably harmful to children. It also requires covered businesses to owe a duty of care to the children whose data is processed. The businesses in this bill are the larger international internet corporations, and we know of no Vermont business that would be negatively impacted by this legislation. It does not control or limit content, as kids have the same freedom of speech rights as adults in our federal constitution. It does limit the harmful algorithms used to addict kids and increases privacy protection so that children are less likely to be the targets of predators. We owe a duty of care to our children to protect them from these harms. Parents try. But parents and their children are completely outgunned by the $300 billion online marketplace. And it's not just a matter of scale. The harms are baked into the programming, and parents can't change the code. Parents are devastated when they can't protect their children. This bill is only necessary because of the intentional and unconscionable harm that large internet companies are doing to our children and have been doing for years. They know that they are harming children, both emotionally and physically, but they keep doing it. They are fighting to keep doing it, with attorneys and proxies doing the heavy lifting. Why are they harming our children? Because it's easier and more effective to addict a child than an adult, just as the tobacco companies did years ago. TikTok has said that they can hook an average user in 260 videos. And 260 videos sounds like a lot, but that's only 35 minutes. So that they are confident that they can addict a child in 35 minutes. Years ago, kids used to work in the mines, in factories, where the damage was easy to see. And we eventually passed laws to prevent child labor. Corporations are now secretly, not as secretly as they were previously, taking advantage of kids, taking advantage of their developing brains to make a profit. And it is beyond the pale. We need to stop it. So what are these harms? In the last session, we heard from and about kids that they are unable to sleep, they're anxious, they're depressed, and sometimes suicidal. An employee of TikTok explained, the reasons kids watch this is a quote, the reason kids watch TikTok is because the algo is really good. But I think we need to be cognizant of what it might mean for other opportunities. And when I say other opportunities, I literally mean sleep and eating and moving around the room and looking somebody in the eyes, end quote. That's what they said to each other. This session, we heard again how kids are targeted through coding intentionally designed to addict them to the social media site. This addiction results in a whole host of documented harms. Why would the companies do this if it harms their users? Again, most importantly to the companies, this addiction leads to increased screen time, which is the moneymaker for the companies. A company can charge more for ads when it can demonstrate that more people are seeing those ads, especially kids. I won't go through the folks we heard from, but you'll be hearing from many of the folks we heard from. I need to share a story that will be difficult to hear. Attorney Laura Marquez Garrett of the Social Media Victims Law Center is working with families in Vermont. She shared with our committee the story of two Vermont girls. The families allowed her to share the story with us because they hope that it will help bring change. She used the names Shannon and Elizabeth to protect their privacy. A few years ago, the two friends joined Snapchat with their parents' permissions, entered their real ages, and chose non-public profiles. They did everything that they were supposed to do. The girls soon showed the classic signs of compulsive use: trouble sleeping, no interest in previous activities such as gymnastics, just a need to keep using Snapchat, mostly on gaming consoles. But it gets worse. Snapchat has a friend recommendation feature and suggests other users as, quote, friends you may know. They provided Shannon's profile to a 24-year-old man who lived nearby, recommending that they become friends. The girls thought he was a 13-year-old boy and snuck out of their house and met the man at a middle school. He drove them to an empty field, plied them with vapes and alcohol, and sexually assaulted Shannon. She was 12. He drove away with their shoes and coats. It was winter, and they could have died. Fortunately, an off-duty police officer saw them and took them home. 5 years later, they're ready to tell their story. Because Vermont seals sex abuse cases, we don't have the details of this as a public item, but there's a case in Connecticut with the exact same issue. And I'll go through just a couple of sections of the bill that I think are important, and obviously you'll get the full rundown from Ledge Council. We don't know of any Vermont-based business that would not be exempt. We added thresholds into the bill. That's how we modified the bill to reduce the likelihood of businesses in Vermont being included. It's important to note Section 2449C sets the minimum duty of care to minors required of covered businesses. And that minimum duty of care is important to be able to keep up with the legal process. And you can talk to some of the folks who are going to provide testimony about that. Section 2449D requires covered businesses to have their default privacy settings set to the highest level of privacy, including preventing a child's social media account being publicly visible. It also requires the default privacy settings to prevent an unknown adult from contacting a child on their platform and from sending a push notification to a child. These regulations would prevent the pedophile as friend recommendation from Snapchat in two ways. The girls' accounts would not have been public, and the unknown adult would not have been able to contact Shannon. Section 2449E requires covered businesses to provide privacy information and detailed descriptions of their algorithmic recommendation system. And this would help parents and kids understand how their information could be used. And it might encourage companies to stop using the algorithms if the public response was negative. And Section 2449G talks about how a covered business regulates how a covered business can determine the age of its users. And that's obviously important for many reasons. In the Snapchat situation, in many situations, evidence supports the intentionality to connect young girls to adults who may be predators. 17 and 18-year-old women on Snapchat say that they no longer receive the friend recommendations that they did when they were younger. Evidently, they've aged out of the preferred demographic. Yeah, it's horrible. Yeah. You can please ask the witnesses. The language in the bill promoting equity would actually prohibit this method as discrimination against minors. Finally, the last two sections clarify the bill does not conflict with federal law or restrict the freedoms children have when it comes to accessing content. The second type of really bad story that we heard in the Senate was a different group of kids being sextorted. And again, when you hear, I believe you're going to hear from Laura Marquez Garrett. And what she told us was many of you have seen reports of teens sextorted and dying by suicide. Please look closely and you will notice that many of these teens are school athletes. That is not a coincidence. It's the result of the fact that Instagram, one of the most commonly used platforms by schools to tout sports teams, is designed and being operated in a way that makes it easy for predators to find and target those children specifically. I have to believe that if adults know that this is happening, they would do something. We are those adults, and it's time to show that we have a duty of care to our children. They deserve no less. So let me just one more thing, and this I didn't include in, well, we didn't have to take testimony on it, but there was a situation that happened February 26th, where it came out that Meta had or was pushing violent, gory reels to adults. Adults got upset at that. Those violent, gory reels are sent to kids every day intentionally. Meta was able to stop that in 2 days, so they can behave and they can stop hurting our kids, and we can help them do it. Thank you very much.
First of all, I love this bill, everything. Except one area where I'm a little, like a little clarification. So section 2449F, section 3, prohibited data and design practices. One of that says, including a parent or guardian of a covered minor to monitor online activity of a covered minor. In my mind, I know what you're talking about. I can tell you, having had children that are now adults, they had their little codes like POS, parents over shoulder.
Yeah.
And they knew when the parents were keeping an eye on things. And I feel like by putting this in there, are we preventing the parents, the people who are the most vested in the safety of these children, their own parents, are we preventing them from doing some sort of intervention to stop some of these things that you were just talking about? So I'd like you to explain a little more about that.
When we had parental, some parents don't have a good relationship with their kids. Most do, and parents are obviously critical to this. Parents can't change the code, right? That would be the most effective thing if they could do is if they could change the code. Sure. So there's a balance between making sure the kids are protected, and making sure the kids are protected is the primary purpose of this bill. So definitely bring that up in committee and talk to the Ledge Council about it. But we struggled with that, but we think it's a reasonable balance, but it's hard to explain to parents too. But I think that when parents understand what is happening to their kids, they will support this. It's just unknown. And the contrast between Meta agreeing immediately that this is bad for adults, they're doing that to kids who don't have their frontal lobe isn't connected yet, right? It isn't fully formed. And this kind of media can actually change kids' brains forever. I hope you'll take testimony about that. So it's physical harm in ways we can see and not see. And we can stop it.
Thank you.
Thank you. Thank you very much for taking this up.
Morning.
Good morning.
Spread out here. It's nice. Rick Sagel, Office of Legislative Counsel. Gonna share S69 as passed by the Senate. Okay, so Senator Harrison gave you a good overview of the bill. I think I'll just give you a walkthrough, and I can't read this is one of those bills where it's 23 pages, is pretty dense, kind of like the data brokers bill. Half of it our definitions again, which is pretty typical on these data bills. So I'm going to read through as much as I can. Like I'm going to skip affiliate because affiliate's a pretty standard definition of what is an affiliate. I can always go back and reference it if you all have questions about a certain definition. So going down to bottom of page 1, age assurance. This will be critical once you understand what this is and how it's done. But it's a range of methods used to determine, estimate, or communicate the age or an age range of an online user. So a lot of this bill is going to be covered businesses being able to know what the age of their users are, and they'll be given different tools to do that, along with the AG providing some guidance on that. Top of page 2, algorithmic recommendation system. I think we all know what that is at this point. It's a system that uses an algorithm to select, filter, and arrange media on a covered business's website for the purpose of selecting, recommending, or prioritizing media for a user. Biometric data is individuals' unique biological, physical, or physiological characteristics that include your iris or retina scan, your fingerprints, your facial hand mapping, vein patterns, voice prints, gait, or other personally identifying physical movement or patterns. It does not include, importantly, a photograph, either digital or physical, an audio or video recording, and any data generated from a digital or physical photograph or audio, video recording, unless that data is generated to identify a specific individual. Again, it'll make more sense once you see how the bill regulates biometric data. Business associate is a HIPAA definition. Collect means that buying, renting, gathering, obtaining, receiving, or accessing any personal data by any means. This includes receiving data from the consumer, either actively or passively, or by observing the consumer's behavior. Compulsive use is important. It means the repetitive use of a covered business's service that materially disrupts one or more major life activities of a minor, including sleeping, eating, learning, reading, concentrating, communicating, or working. And you'll see one of the minimum duties of care is that a covered business cannot create this kind of compulsive use of one of their online services. A consumer is an individual of Vermont. It is not an individual acting in an employment context, government agency, etc. Pretty standard consumer, not consumer definition here. Consumer health data means any personal data that a controller uses to identify a consumer's physical or mental health condition or diagnosis. A controller is a person that, alone or jointly with others, controls, determines the purpose and means of processing personal data. Okay, important definition, covered business. It means a sole proprietorship, partnership, LLC, corporation, association, other legal entity, or an affiliate that A, conducts business in the state, B, generates a majority of its annual revenue from online services, C, whose online services, products, or features are reasonably likely to be accessed by a minor, D, that collects consumer personal data or has consumer personal data collected on its behalf by a processor, and that alone or jointly with others determines the purposes and means of processing of consumer personal data. So, we have kind of the narrowing here of what a covered business is. It must meet all 5 of those elements for a business to be a covered business. Covered entity is a HIPAA definition. A covered minor is a consumer who a covered business actually knows is a minor or labels as a minor pursuant to age assurance methods and rules adopted by the AG. So when you know someone's a minor, that is a high standard. That is, it's not just reasonable anymore. You have data showing this consumer is a minor. You know it's a minor. So that's the definition, or the age assurance message we'll talk about later. Default is a pre-selected option. You all know what that is, I think. 15, de-identified data is data that does not identify and cannot reasonably be used to infer information about or otherwise be linked to an identified or identifiable individual or a device linked to an individual if the covered business that possesses the data, A, takes reasonable measures to ensure that data cannot be used to re-identify an individual or be associated with an individual or a device that is linkable to the individual or their household. 2, for purposes of the subdivision, reasonable measures includes the de-identification requirements set forth under a federal law that is HIPAA related. B, publicly commits to process the data only in a de-identified fashion and not attempt to re-identify the data. And C, contractually obligates any recipients of data to comply with all provisions of the subchapter. So you'll notice that, especially when we talk about the data privacy later, de-identified data is treated differently because it cannot be linkable to an individual. So 16, derived data means data that is created by the derivation of information, data, assumptions, correlations, inferences, predictions, or conclusions from facts, evidence, or another source of information or data about a minor or minor's device. Genetic data, just what it sounds like. It's DNA, RNA. I'll let you read that to understand what genetic data includes. Identified or identifiable individual means an individual who can be readily identified, directly or indirectly, included by reference to an identifier such as name, an ID number, specific geolocation data, or an online identifier. So known adult is the same thing as known minor, except this time the cover business actually knows the consumer is an adult, or through age assurance methods, they determine it's an adult. A minor is someone under 18 who is a resident of the state. Neural data is information collected through biosensors, and that could be processed to infer or predict mental states. Okay, important definition 22. Online service, product, or feature means a digital product. So that's already limiting, right? That is accessible to the public via the internet, including a website or application, and does not mean any of the following. Telecommunication service. So this is your phone lines, AT&T, the intent here is you don't want to capture the providers of the data that is like transmitting the data. So B, broadband, so your ISP, they also are not included in this, that they are just the communication service that's providing the content. They are not creating the content. Or C, the sale, delivery, or use of a physical product. So again, just digital products, not anything physical or that you can tangibly hold. 23A, personal data, means any information, including derived data and unique identifiers, that is linked or reasonably linkable to an identified or identifiable individual, or to a device that identifies one or more individuals in the household. It does not include de-identified data or publicly available information. More about that in a second. Precise geolocation data is information derived from technology that reveals the past or present physical location of a consumer or a device that identifies a consumer within a radius of 1,850 feet. It does not include the content of communications, data generated by or connected to an advanced utility metering infrastructure system, a photograph or metadata associated with a photograph or video that cannot be linked to an individual, or data generated by equipment used by a utility company. Process means any operation or set of operations performed on personal data or on sets of personal data, such as collection, use, storage, disclosure, analysis, deletion, modification, or otherwise handling of personal data. Processor is a person that processes personal data on behalf of the covered business. Profiling means any form of automated processing performed on personal data to evaluate, analyze, or predict personal aspects related to an identified or identifiable individual's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. Publicly available information is information that is made available through federal, state, or local government records, or a controller has a reasonable basis to believe that the consumer has lawfully made available to the general public. It does not include biometric data collected by a business about a consumer without the consumer's knowledge. It does not include information that is collected and combined to create a consumer profile that is made available to a user of a publicly available website, either in exchange for a payment or free of charge. Information made available for sale, and inference that is generated from the previous two subdivisions, any obscene visual depiction, any inference made exclusively from multiple independent sources of publicly available information that reveals sensitive data with respect to a consumer, personal data that is created through the combination of personal data with publicly available information, genetic data, unless otherwise made publicly available by the consumer to whom the information pertains, information provided by a consumer on a website or online service made available to all members of the public for free or for a fee, where the consumer has maintained a reasonable expectation of privacy in the information, such as by restricting the information to a specific audience, or, again, this is publicly available information, what it doesn't include, or intimate images, authentic or computer generated, known to be non-consensual. Reasonably likely to be accessed means an online service, product, or feature that is reasonably likely to be accessed by a covered minor based on any of the following indicators. The service is directed to children as defined by COPPA, C-O-P-P-A. That's a federal law that regulates children's privacy online, and the FTC rules implementing that act. The online service is determined based on competent and reliable evidence regarding audience composition to be routinely accessed by an audience that is composed of at least 2% minors 2 through 17 years of age. The online product or feature, service, product, or feature contains advertisements marketed to minors. The audience of the service is determined based on internal company research to be composed of at least 2% minors 2 through 17 years of age. Or the cover business knew or should have known, that's a reasonable standard, that at least 2% of the audience of the online service includes minors 2 through 17 years of age. Provided that in making this assessment, the business shall not collect or process any personal data that is not reasonably necessary to provide the online service which the minor is actively and knowingly engaged. Sensitive data is personal data that reveals a consumer's government-issued ID, such as social security number, passport number, state ID, driver's license number, reveals a consumer's racial or ethnic origin, national origin, citizenship, or immigration status, goes on, reveals a consumer's sexual orientation, sex life, sexuality, reveals a consumer's status as a victim of a crime, is a consumer's tax return and account number, financial account login, financial account, debit card number, goes on. Is consumer health data, is collected and analyzed concerning consumer health data that describes or reveals a past, present, or future mental or physical health condition, treatment, disability, or diagnosis, including to the extent that personal data is used by the controller for a purpose other than to identify specific consumer's physical or mental health condition. And then are a few more here: biometric or genetic data, collected from a covered minor, precise geolocation data, keystrokes, driving behavior, or neural data. Almost done with definition. Social media platform means a public or semi-public internet-based app, service, or app that is primarily intended to connect and allow a user to socially interact within such service or application, and enables a user to, 1, construct a public or semi-public profile, populate a public list of other users with whom the user shares a social connection with, create or post content that is viewable by other users, including content on message boards and in chat rooms, and that presents the user with content generated by other users. It does not mean a public or semi-public internet-based service or application that exclusively provides email or direct messaging, primarily consists of news, sports, entertainment, interactive video games, electronic commerce, or content that is pre-selected by the provider for which any interactive functionality is incidental to, directly related to, or dependent on the provision of such content, or is used by and under the direction of an educational entity, including a learning management system or a student engagement program. And then we have third party, which is a pretty standard definition. Questions about definitions?
So. Hey, stupid question. Because it's not just like an Amazon type thing, but Temu. Where would that fall into? Temu does use data analytics to push stuff onto you to make you buy stuff. Is there, where would that fall into? Because it's not a social media platform technically.
So far, they, you look at cover business, right? And you see,
Commerce.
do they fit the definition of cover business? And you would say, probably yes, right? But then you go down to see, are there any other kind of narrowing of the definitions? And you would say, well, are they a social media platform? And I don't use Temu. It's like Amazon, right? It's like
Yes,
a
e-commerce.
e-commerce. So
Don't they push stuff? I've never used it, so.
it's in one of the exceptions of social media, but
Okay.
one thing about this bill is you had cover businesses, that's one bucket. You have some cover businesses do social media, some don't. Let's say Temu doesn't, right? They're still a cover business, but when it comes to the bill as it pertains to social media platforms, then they probably would not be covered. It'll make more sense once we get through all the layers of this. Okay, exclusions. So you can be a covered business, but then it could be excluded because of one of these exclusions. If you're a federal, state, tribal, or local government entity in your ordinary course of operation. So if you're a town that has a message board for some reason, I don't know why you would do that, but you would not be included because you're a local government entity. Two, protected health information. HIPAA, if you all have questions about the HIPAA connections, I would have probably my colleague Jen Carby come in. She's the HIPAA expert, and she'll know more about that than I would. Same thing with three, another health data issue. Four as well, A and B, certain research done at the federal level is given protection. I'm going to skip down to five. So again, these are exclusions. An entity whose primary purpose is journalism, and that has a majority of its workforce consisting of individuals engaging in journalism. This is intended to capture legitimate news organizations that produce news that employs journalists as their majority of their workforce. Six, a person who controlled or again, remember, person is a wide definition. Person includes everything, right? LLCs, corporations. A person who controlled or processed the personal data of not more than 25,000 consumers in the previous calendar year, excluding personal data that's processed for a payment transaction. So if you processed less than 25,000, you are going to be excluded from this bill. No matter where you are in the world, if you process less than 25,000, you would not be you'd be excluded from this bill. Also, if you process less than 50,000 in the previous calendar year, excluding payment transactions, and you had a annual gross revenue of not more than $1 million, you would also be excluded. So if you processed 35,000 people, you would not be excluded in Part A, but if you processed 38,000 but had annual revenue of under $1 million, then you would also be excluded from the bill. Does that make sense?
Can you explain why we're doing that? Yeah, I mean, legitimate, I mean, I just don't understand.
So I can't speak to the intent, but the legal ramification is a business that would normally be included in the bill scope. Small business that doesn't process many people, they would not be lumped into this bill. It was a choice of the Senate committee that did this to add that language in. I can say that this 5A and B were not, or 6A and B were not in the introduced version of the bill. The Senate added 6A and B.
So this could be business protection for Vermont business that may do the same things that these big businesses do.
Just remember, it applies to every business that processes under 50,000, right? So it could be a California company that processes 24,000. They would not be included because they process under 25,000.
I'm saying that's okay.
You're saying they're excluded from the bill.
Okay,
Basically, it's okay to go after kids.
yeah,
Okay, that's not That's the policy choice that was made in the Senate.
The definition of consumer here?
Yes.
is Vermonter or anyone using the program?
Consumer is an individual in Vermont, so yes, someone who has a residency here.
How many kids are in the school system?
About 90,000, but that's, college, we have a bunch of 17-year-olds that are here for college, but once they turn 18, they're not minors anymore.
But they are consumers. Consumers include adults.
Consumers includes
Yes.
adults. That's
Yes.
helpful.
Yeah.
And then, so consumers, including adults, and on a platform that has, that knows that they have at least 2% minors.
For social media, yeah, there's several layers of this, and that's why it gets a little bit,
It's a
tricky.
little confusing.
Yeah.
I feel like I would like to hear more about the reasoning for putting that in there, just as a,
We get to choose our policy.
no, I know. It seems arbitrary and it also seems like it's not doing what we want.
My recollection is in that Senate committee, there was discussion about not including Vermont businesses, and this was the attempt to avoid that. But again, that's a policy choice that they made.
Even Vermont businesses can be evil.
And we have subdivisions 7, a financial institution or data subject to the Graham-Leach-Bliley Act, common exception in these data bills. Okay, so we have the first actual, restriction here or kind of guidance to these businesses that may be covered by the bill. So 2449C is the minimum duty of care. Subsection A covered business, which, you know what that definition is, that processes a covered minor's data in any capacity owes a minimum duty of care to the covered minor. So that doesn't mean much right there, right? We have to kind of know, what does minimum duty of care mean? So subsection B, a minimum duty of care means the use of the personal data of a covered minor and the design of an online service, product, or feature will not result in 1, reasonably foreseeable emotional distress as defined in our statutes. I would ask, I don't have it pulled up, but you should look at that definition. It's pretty severe, that type of emotional distress. 13 VSA 1061-2. 2, reasonably foreseeable compulsive use, which we have defined, of the online service, product, or feature by a covered minor, or discrimination against a covered minor based upon race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, or national origin. Okay, so again, remember we have a definition of online service, product, or feature, right? So a covered business that has a online service, product, or feature, which is not a physical product, it must be an internet-based website application, right? So if some covered businesses don't offer online services or products, right? Most of them probably do. But you have to be a covered business, and then you have to offer some type of online service, product, or feature that if you do, then you must follow these 3 things to satisfy the minimum duty of care. C, kind of an exception, the content of the media viewed by a covered minor shall not establish emotional distress or compulsive use as those terms are defined. So just merely providing content to the minor cannot establish that. It must be the use of the system itself, not the actual media you're observing on the platform.
Can I go back to B, the introduction to that, paragraph? It says minimum duty of care means the use of personal data of a covered minor and the design of an online service, product, etc. Both elements would need to be
Good catch, yes.
Present.
Correct. So good, yes, thank you. So the meaning that 2 things, that how the personal data is used and the design must meet these 3. Yep. Subsection D, nothing in this section shall be construed to require a covered business to prevent or preclude a covered minor from accessing or viewing any piece of media or category of media. This is to avoid a potential First Amendment issue. If a minor requests to view content that is something the covered business may not show them in their algorithm by default, this covered minor still should receive that media. Because otherwise you're restricting the access to media, which is a First Amendment problem. 2449D, required default privacy settings and tools. Default privacy settings. A covered business shall configure all default privacy settings provided to a covered minor through the online service product or feature to the highest level of privacy, which includes the following default settings. Not displaying the existence of the covered minor social media account to any known adult user unless the covered minor has expressly and unambiguously allowed a specific known adult user to view their account or has expressly and unambiguously chosen to make their account's existence public. B, not displaying media created or posted by the covered minor on a social media platform to any known adult user unless the covered minor has expressly and unambiguously allowed a specific known adult user to view their media or has expressly and unambiguously chosen to make their media publicly available. C, not permitting any known adult users to like, comment on, or otherwise provide feedback on the covered minor's media on a social media platform unless the covered minor has expressly and unambiguously allowed a specific known adult user to do so. Not permitting direct messaging on a social media platform between the covered minor and any known adult user unless the covered minor has expressly and unambiguously decided to allow direct messaging with a specific known adult user. Not displaying the covered minor's location to others unless they have expressly and unambiguously shared their location. Not displaying the users connected to the covered minor on a social media platform unless. Disabling search engine indexing of the covered minor's account profile and not sending push notifications to the covered minors. So again, these are default settings. The covered minor can change these settings to allow these things to happen, but it must be express and unambiguous. So probably not one checkbox that says undo all this. Probably has to be checkbox, 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 right?
Which probably means when they're setting up the app, they'll have to go through a list of things do they want,
I would imagine, yeah,
instead of making it so that they have to go out of their way.
I would imagine.
Well, that's very unfortunate. You should have to go out of their way.
But to undo the default settings.
Correct.
Good.
Because you know that's how they'll get around it. They'll just do the pop-up. Do you want notifications?
Well,
Do you want?
so to your point, a covered business shall not provide a covered minor with a single setting that makes all the default private settings have less protection. So can't be one checkbox, but I'm not sure how it's going to work out in practice. Like it could be that easy to do that. I don't know. But you can change. So the thing is, you could make it more difficult if you'd like. You could add in some language saying that there should be, however you want to think about that, and we can come up with something. But something that you can do.
It's just as you're setting up your apps, I mean, oftentimes they do automatically pop up. Do you want default settings or not default settings, but do you want to add notifications? And then it automatically prompts you to go to add the notifications. And I'm thinking that it probably should be best that that's not even like the first thing that you get when you're going through it. That should be something that you have to Google and find out how to add those notifications. That's my opinion.
Or you have like a 24-hour wait period. Default settings take, you must wait a certain amount of time before giving the kids the option, something like that.
Oh, I mean, yeah. Sure. Like to do that 24 hours
It's just an idea. I don't know why.
or how about 5 years?
Might be unreasonable. Okay, a covered business shall not provide a covered minor with a single setting that makes all the default privacy settings less protective at once, or request or prompt a covered minor to make their privacy settings less protective unless the change is strictly necessary for the covered minor to access a service or feature they've expressly and unambiguously requested. So that kind of goes back to what you were saying. I think maybe you can be more clear if you want to add that type of protection for minors.
Repeat that. I lost train of thought.
Subdivision B, so a covered business shall not request or prompt a covered minor to make their privacy settings less protective unless the change is strictly necessary for the covered minor to access a service or feature that they have expressly and unambiguously requested.
So yeah, That takes care of that.
Subsection B, timely deletion of account. A covered business shall provide a prominent, accessible, and responsive tool to allow a covered minor to request the covered minor's social media account be unpublished or deleted, and honor that request not later than 15 days after covered business receives the request. Okay, transparency. A covered business shall prominently and clearly provide on their website or mobile app, one, the covered business's privacy information, terms of service, policies, and community standards. Detailed descriptions of each algorithmic recommendation system in use by the covered business, including the factors used by algorithmic recommendation system and how each factor is measured or determined. Uses the personal data of covered minors. Influences the recommendation issued by the system and is weighed relative to the other factors listed in the subdivision. 3, descriptions for every feature of the service that uses the personal data of covered minors of the purpose of the feature, the personal data collected by the feature, the personal data used, how it's used, and any personal data transferred to or shared with the processor or third party by the service feature, the identity of the processor and the purpose of the transfer or sharing, and F, how long the personal data is retained. 2449F, prohibited data and design practices. So this is the data privacy section. Most of the bill so far has been about the design of the service, right? How you should have to owe a minimum duty of care. This is more about how you handle the privacy of minors. A covered business shall not, 1, collect, sell, share, or retain any personal data of a covered minor that is not necessary to provide an online service, product, or feature with which the minor is actively and knowingly engaged. I do have a comment about that I'll get to at some point, but this could be too broad of a statement. That's my concern with that one, but I'll get to that later. 2, use previously collected personal data of a covered minor for any purpose other than a purpose for which the personal data was collected, unless necessary to comply with any obligation under this chapter. Permit any consumer, including a parent or guardian of a covered minor, to monitor the online activity of a covered minor or to track the location of the covered minor without providing a conspicuous signal to the covered minor when the covered minor is being monitored or tracked. You had a question about that. Did you need me to follow up at all with?
I mean, my thing is that the primary means of preventing a lot of this is parents having intervention. I mean, we hear it all the time in the news about kids getting into all sorts of trouble, and you talk to parents that we had no idea.
Yeah.
And kids, I mean, especially the older kids, I mean, they're smart enough. I have 2 granddaughters, one's 12, one's 14. They know when their parents are looking, and they know to tone down what they're talking about. And as soon as mom and dad leave, they're back at whatever they're talking about. And so that's really, I feel like we need to give parents more power over their children. I mean, to your point, I would love to see it where everything's locked down until the parent gives permission to unlock everything.
Right.
Because I think we're eliminating the number one barrier to a lot of the stuff that goes on, and that's the parents.
So to directly answer what this bill would do, it would require, a conspicuous signal. And I don't know what that looks like. That's a question for someone else. But something when they're on either the website or the application on their phone, that if the parent is tracking them, that there would be some kind of signal showing the minor. So you can think about this as far as the age of the minor. Are we talking about a 5-year-old? Are we talking about a 17-year-old? That could also be something to consider. Maybe you think about having that depend on the age of the minor. It's something you can think about. But the way it's written right now would require some kind of signal to the minor that they're being monitored or tracked.
Right. And my concern is, oh, my parents are watching, so let's go off to this other site where we can really talk. And then you've completely circumvented the entire bill.
Could happen. Subdivision 4, again, this is a covered business shall not use the personal data of a covered minor to select, recommend, or prioritize media for the covered minor unless the personal data is A, the covered minor's express and unambiguous request to receive media from a specific account, feed or user to receive more or less media from the account, feed or user, a specific category of media. Sorry. I don't know if we've ever done this before, where we have the phrase cat videos in a bill, but here it is. A specific category of media, such as quote cat videos or quote breaking news.
I'm addicted.
But it helps understanding, I think what the intent is here, but or to see less or more of that category, or more or less media with similar characteristics as the media they're currently viewing. So again, unless the personal data is user selected privacy or accessibility settings, or a search query, provided the search query is only used to select and prioritize media in response to the search. Nor shall they send push notifications to a covered miner between 12 midnight and 6 a.m. So that's like a never thing, right? This is not there. You may remember earlier there was a not send push notifications. That was the default setting, which a miner can change. This a miner could not change. So just keep that in mind, is that there would be no push notifications from 12 to 6 to miners. Rulemaking. The AG shall have the authority to adopt rules pursuant to the subchapter that prohibits data processing or design practices that, in the opinion of the AG, lead to compulsive use or subvert or impair user autonomy, decision-making, or choice during the use of the service. The AG shall, at least once every 2 years, review and update these rules as necessary to keep pace with emerging technology. So the intent here is that it's going to be impossible to legislate all this, and you want an entity to oversee this, and the choice is the AG for that. Age assurance and privacy. So cover businesses and processors shall only collect personal data of a user that is strictly necessary for age assurance. Again, this might be too broad. Might want to narrow this a little bit. 2, immediately upon determining whether a user is a covered minor, delete any personal data that collected of that user for age assurance, except whether the user is or is not determined to be a covered minor. 3, not use any personal data of a user collected for age assurance for any other purpose. 4, not combine personal data of a user collected for age assurance with any other personal data of a user, except whether the user is or is not determined to be a covered minor, and implement a review process to allow users to appeal their age designation. So, and we have rulemaking here as well. So I think the intent here is you want to give covered businesses the tools to determine, hey, do we have 2% of our users that are between 2 and 17? So you have to give them the ability to do this, to process data, to determine how old are our users. Otherwise, we're not going to know, right? So this is the tool that covered businesses can use to do that. However, there are limitations on it. And then you have the AG that also is going to provide feasible methods here for covered businesses on or before July 1st, 2027, to help them further determine how are we going to comply with this. We have to process data, but we have to do it in a way that's maintains privacy for the miners. In adopting these rules, the AG shall prioritize user privacy and accessibility over the accuracy of age assurance methods, and consider the size, financial resources, and technical capabilities of covered businesses and processors, the cost and effectiveness of available age assurance methods, the impact of age assurance methods on a user's safety, utility, and experience, whether and to what extent transparency measures would increase consumer trust in these methods, the efficacy of requiring covered businesses and processors to use previously collected data to determine age, adopt interoperable age assurance methods, and provide users with multiple options for age assurance. Enforcement calls in Section 2453, which is the Vermont Consumer Protection Act, which means the AG or a person, private person, can institute an action against a covered business or a processor for a violation. Subsection B, the AG has the same authority to make rules, conduct civil investigations. So you have these two paths, like in the data brokers bill. You have the person through the Consumer Protection Act, or you have the AG through enforcement as well. Limitations. Subdivision 1, this is a federal law that basically says The example I use is Yelp, which I probably need to update my reference, but if you post a review to Yelp that is offensive or something, it's not Yelp's responsibility for that content. Yelp maybe has to take it down, but Yelp is not responsible for the content of that review, right? So we're not going to hold liable the content providers, just potentially here under federal law, just the creators of the content, and with some exceptions to that. 2, prevent or preclude any covered minor from deliberately or independently searching for or specifically requesting any media. And then clarification that nothing in the subchapter should be construed to infringe on the existing rights and freedoms of covered minors, or be construed to discriminate them for several different reasons. The effective date is July 1st, 2026, and the intent there is to give time for the covered businesses to comply with the terms.
Hey, Rick,
Yeah, you're welcome.
you get the floor. I think it looks like we're having a caucus of the whole after we finish floor. Don't know if caucuses are gonna happen, but I hear 1 o'clock to take testimony. We can go off